Please welcome Acting President Claire Shipman.
Hello, everyone. Good afternoon, and thank you so much for coming. I remember when the Institute of Global Politics launched in the fall of 2023, and I have to say, it has been incredible to watch it grow and flourish under the leadership of Karen Yarhy-Milo and Secretary of State Hillary Clinton. It's no easy feat to bring together experts, people with strong opinions and diverse, well, I should say at Columbia, it's really easy to bring together people with strong opinions and diverse views, but it's not easy to bring them together to have honest and open conversations about issues that matter and that are really hard to have. This team has been doing just that month after month and modeling these difficult conversations. As a SIPA alum and now acting president of Columbia, I could not be more proud. This is a tough time for universities and their communities. We all feel it. I think the road ahead will be challenging. There's no getting around it, but I'm standing here today because Columbia changed the course of my life, starting when I arrived here in 1982 as an undergraduate. I was a student at Columbia College and then at SIPA, and that showed me the possibility and the value of engaging in rigorous debate with some of the world's brightest minds, and for that I will be eternally grateful. Columbia really pushed me to work harder. It pushed me to question my own assumptions, to absorb as much knowledge as I could, and to think more expansively and creatively than I ever thought was possible. In fact, I remember one of the classes I took at SIPA, which at the time was controversial, helped me to focus on Ronald Reagan and the critical role he had played ending the Cold War. And this was not the orthodoxy at the time, and it was an incredible mind-opening exercise for me. That is what SIPA does, and it does it better than ever now with IGP. That is what we do here. We teach, we learn, we create new knowledge, we drive society forward, and I think fostering dialogue is essential to Columbia's DNA, and we're doing it so much better now under the guidance of this institute. That's what we're hoping to do here tonight, is to host a timely and important conversation about the judiciary. It couldn't really be more topical, and the role it plays in sustaining American democracy. This work and these difficult conversations are not always easy, but we have to continue to do it in our classrooms, with friends in our dorms, with friends I see here who are on the board with me. We're all having these conversations, and we need to do it publicly and privately and in a world beyond Columbia for the success of our community, but for the success of the world at large. And with that, I'd like to turn the podium over to our beloved SIPA Dean, Dr. Karen Yarhy-Milo, who will say a few words and then introduce our illustrious panel. Karen.
Thank you, Claire. Thank you for joining us, for your many years of support for SIPA and IGP, and for stepping into the role of acting president at this challenging moment. We are all very, very grateful. Good evening, everyone. It's a real pleasure to welcome you to tonight's discussions on the judiciary, hosted by the Institute of Global Politics. Tonight's event is part of IGP's Across the Aisle series. We kicked off the series when we launched the Institute of Global Politics back in October 2023. Our goal was to bring together distinguished leaders from across the political spectrum and with divergent perspectives to engage in real dialogue on the most pressing political policy challenges of our time. And I have to say, Across the Aisle has really quickly become one of our most popular and impactful series. And tonight's conversation continues that tradition. We created this series with a purpose, to model what civil discourse looks like at a time when polarization is rising. It's rising on campuses and across the country. And when disagreement dominates headlines, We believe really that it's more important than ever to show that respectful, meaningful dialogue isn't just possible, it's actually essential to a healthy democracy. And tonight's guests embody these principles. As longtime friends, our panelists serve as a reminder that we can hold opposing views and still hold each other in high regard. That's a value we believe in deeply and at Columbia. And to the students in the room, I urge you to emulate this in your own friendships and networks. The more perspectives you wrestle with, the stronger you will be. Not just as professionals, but as citizens in a democracy that really depends on dialogue across differences. Few institutions are as fundamental to that democracy as the judiciary. And tonight's conversation will explore the court's role in upholding the Constitution, interpreting the law, and navigating their place in our increasingly polarized public space. Now, this conversation could not have come at a more critical moment. In recent weeks, we've seen the judiciary under real pressure, from executive actions targeting law firms to federal judges facing threats and calls for impeachment. Now, these developments raise urgent questions about the balance of power and the resilience of our legal institutions. That's why we are especially fortunate to have with us two highly respected federal judges who bring extensive experience and different perspectives to this conversation. And I am grateful to them for taking time out of their very busy schedules to join us this evening. And I want to first introduce Judge Roy Altman, appointed by President Trump to the U.S. District Court for the Southern District of Florida. At 36, he became the youngest federal district court judge in the country, and we are proud to count him among our IGP Carnegie Distinguished Fellows this year. And I'll also note that he is a graduate of Columbia College. Joining him on stage is Judge Stephen Higginson, appointed by President Obama to the U.S. Court of Appeals for the Fifth Circuit. He also previously served as an associate professor at Loyola University in New Orleans and College of Law, and both bring a wealth of insight and a spirit of open engagement that exemplifies what this series is really all about. I'm sure it's going to be a wonderful, insightful conversation. Moderating tonight's discussion is Professor Jamal Green. He's a leading constitutional scholar and a Dwight Professor of Law at Columbia Law School. Widely published, he's also the author of the book How Rights Went Wrong, a powerful exploration of how our legal culture navigates rights and responsibilities in divided society. So together, their conversation will help us understand how judges interpret the law, how they navigate their role in civic life, especially during moments of deep political divisions. Before we begin, I'd like to offer special thanks to the Office of the President for their collaboration on today's event, and to the University Programs and Events team for their outstanding support, and to the team at IGP for putting this together. With that, I'll turn it over to Professor Green to begin our discussion. Thank you so much for joining us.
Thank you, Karen. Thanks to Acting President Shipman. Thanks to IGP for inviting me to be part of this conversation. And thanks most of all to our guests, Judge Altman and Judge Higginson. I'm going to try to have a conversation. I have a few questions in mind, but as Judge Altman and Judge Higginson respond, I may audible a little bit and try to really make it into a conversation and really get into questions of the role of judges in this moment in which we find ourselves and the role that disagreement and agreement can play in the lives of people who are public figures who have influence over others in various ways. I want to start with a question about your relationship with each other. We're told that you're good friends, and yet, Judge Altman, you were appointed by President Trump. Judge Higginson, you were appointed by President Obama. President Trump and President Obama are not known to be good friends with each other, and yet you have a warm relationship. You want to tell us a little bit about how you came to know each other and how your relationship has evolved over time?
Sure. First of all, thank you for having me, and thank you for Professor Green for moderating the panel. And Steve, as we're about to explore, he doesn't like to be here, okay? He doesn't like to come out of chambers, but he did it because he knows that it's important and because he trusts me and because we're friends. And the way we met was actually apropos of that conversation. We are part of a program. It started at the Aspen Institute, but it moved over to what's now called the Rodell Judicial Fellowship. It started for politicians, and they would take about 20 or so state and local politicians, 10 from each party, and they're usually mayors and councilmen and state senators. You've heard of some of their graduates, people like Kamala Harris and Pete Buttigieg. And they bring them together for a 3-year program to talk about working across the aisle and the future of American democracy. And they decided a few years ago that given everything that's going on with the judiciary and the central role the judiciary plays in our democracy, that it might be a good idea to have a program for judges. And so 3 years ago, I think it was, they started a program for federal judges and state Supreme Court justices. Each year they call 16, 8 appointed by Republicans, 8 appointed by Democrats, and we get together once a year for a week in different parts of the world, and we hear from scholars, and we hear from historians and professors, and mostly we talk to one another, and we discuss a lot of different questions relating to the judiciary, but at its core, I think, the central driving theme of the program, which we just finished our 3rd year, is this question: what is the role of a judge, in particular a federal judge, in our 21st century democracy? And I think, and Steve may disagree, what I found over the course of the 3 years, and now having seen the different judges from different years who have participated in the program, is that there's, like anything else, a spectrum of judges' views about what our roles are in public discourse and public affairs. On one end of the spectrum, I would say you've got judges who think we should speak through our opinions. We should speak through our written work. We should remain in our chambers for the most part. And that's our constitutional function. That's where our constitutional role should manifest itself. And of course, like any spectrum, there's people along in the middle, and then on the far, far extreme of that spectrum, you have me. And I firmly believe that judges have a very important role to play in public discourse in a 21st century democracy. That's how we met. I can talk a little bit more about that in a minute. And we became very close friends. From the first day of our discussions, I could tell that he was smart. I could tell that he was open-minded. And most importantly, I could tell that he had a deep love and appreciation for the country. So although we may disagree, for example, on a judge's public role in the community, we agree on first principles, which are that the country is a good thing and that it needs to be protected and defended at all costs, and that the judiciary and we as individual judges within that judiciary have a critical role to play in that shared mission.
Thank you for having me here. I was at this event, that's this program that began. I happened to be seated next to Roy, and I was told I had 5 minutes to find out about this stranger, and then I had to introduce him to everybody else. And if you look up Roy on Wikipedia, you'll see why that's an impossible task. The judiciary is a small branch. You get to know each other easy. He's pretty irresistible. So when he called and asked me to come here, I did. I hope we'll be provocatively different in our outcome. I was thinking to myself, the formative experience for me, my teachers at college were mostly European Jews who were intellectuals that came over to America and warned about how democracy would fail. One in particular, Judith Sklar. You all may know Elie Wiesel's Perils of Indifference. So when I think of Roy, even though I fault him for his extrajudicial activities, there is no one that I would count on more to prevent the peril of indifference. In other words, if you were to protest against him for being an activist, you'd actually more prefer to protest against a judge like me, who rarely comes out and engages at all. Instead, in other words, if you are concerned about the health of the democracy and rule of law, over time, Roy has challenged me to understand that judges have to step up, as he has. I'll just say qualities of his that really impress me, especially since I see a lot of students out there. He fiercely believes in his convictions, whereas I am often trained as a lawyer and a judge to doubt my convictions, to stay as neutral as possible. He's got a great sense of humor. That's rare, too. He doesn't personalize opposition, and I think that maybe I've guessed that he was a big athlete, where you really can't personalize opposition, and also a trial lawyer. You learn those lessons quickly, both in sports with referees, judges, trial. And lastly, I'm very aware all the time that his lived experience is very different than mine. So I really don't want to discount or judge him based on such differences till I understand them.
Great. I want to ask a question, and here I'm already audibling a little bit, about ideology, which is to say, I think people who encounter the judiciary primarily through the Supreme Court may have a certain picture of what it means to be a judge who's associated with the left versus a judge who's associated with the right, and have a sense of exactly how much disagreement there is on the court. Or if you look at judicial confirmation hearings and at the Supreme Court level and see the kinds of disagreements that are aired in that process, may have a certain sense of what it is that judges disagree about. So I'm wondering if you have any thoughts on how much ideology matters on the courts on which you sit, which is a district court and a court of appeals. When I was clerking at the Second Circuit, which is the court of appeals that sits in New York and that covers New York and Connecticut and Vermont, there were very few cases where there was an obvious difference between the judges on a particular panel, although that court at the time was known as a relatively collegial court. So I'm curious about your own experiences about what does it matter? I mean, we're told in some sense that the law is the law, and you're supposed to follow the law. But of course, who's on the court, who sits on a court matters, and their political appointees. So wonder if you could reflect on that a little bit.
Well, I was pleased to hear that this Across the Aisle series, this is the first time two judges have spoken. And I think our answers are going to partly be different in terms of our situational differences. In other words, the level of court we're at. So I'll talk as to why I think it might be valuable to hear the judicial perspective. It's really important to know the two oaths that judges take. In other words, the first oath requires us to disagree, right? Our only job is to decide cases and controversies. So every litigant wants us to see all perspectives. That's boiled into my brain. That's not ideology. It's an openness to all perspectives. The second oath is our statutory oath, that when we make a decision, it has to be without respect to persons. So you absolutely could never have some hostility to a litigant or to a party, or on my court to another judge. You may disagree with them vehemently, but you've taken two oaths that prevent that. The other three things I was going to say structurally, it may surprise you because judges seem imperious, but there's huge built-in structural humility. I have to take every fact that Roy finds as given. Then at the circuit level, the intermediate appellate level, only the arguments that are presented by the parties are the ones that I primarily should consider. There are exceptions to these, but then I always am subordinate vertically to the Supreme Court. So think of those three different dimensions of humility, accepting other people. his facts, the party's arguments, and the ultimate word is the Supreme Court. On the circuit court, I never sit with less than 2 other colleagues. So I will never prevail unless I persuade another person. That's going to be very different. Actually, frequently, I'm one of 17 on my full court. And I guarantee you, if you disparage a colleague, you will not get their vote. And in fact, usually if you express only certainties, you won't get their vote. I was trying to think, and I'll be less than a minute, again for students, I was trying to think, okay, what have I seen that really makes for good resolution in spite of disagreements? And I came up with 4. The best advocates tend to dignify their opponent. Thurgood Marshall certainly did. It's both clever tactically, because you'll understand the opposing position, but it's also the more persuasive one. I guarantee you as a judge, where we see a lawyer dignifying the opponent, they do better. Second of all, I always start with common ground. Again, I need another vote. I have to anticipate common ground with someone I might disagree with. And in fact, compromise is a positive. Whenever I write an opinion, I will always get a memo from colleagues, and they will concur subject to the following compromises, concessions that I make. Now, 2 final points tactically. If you find yourself disagreeing with someone, this is my own personal habit. My law clerks who are probably watching know this. It's very helpful to think, why are we disagreeing? I tend to reduce it to 3 different possibilities. 1, judges are disagreeing about the past. What is the law that says the answer to the question? Or judges can be disagreeing on a totally different plane. They're disagreeing about the facts of the case. What will be a fair outcome for these litigants? Or judges are disagreeing about the future. What is the appropriate rule of law that will work for people in the future? So if you sense yourself in irreconcilable conflict, try to think, is it the past we're disagreeing about? Is it the parties in the present, or is it the future? Finally, judges have one luxury over students. We will always be heard. In other words, I can always say I want oral argument, interface with lawyers, and I can always then have conference with my colleagues where I have to disagree strongly with them. Also, I can always write a dissent. So the beauty of our position when there's disagreement is we will always get to write and be heard.
Yeah, so obviously, sitting as a district court judge, my life is just different. And in some ways, better for my personality, I decide every question by myself without consulting anyone else. And that's just the loneliness of being a federal district court judge. All the decisions come to me after consultation with the lawyers on either side, and the decisions are made by the judge. Now, in response to Professor Green's question, I think he's right that outside of the Supreme Court, even at the Supreme Court, the vast majority of the cases are probably seen the same way by most of the judges. You see the numbers coming out of the Supreme Court every year show that most of the cases are decided 9-0 or 8-1 or maybe 7-2. It's probably the case on the district court that most cases will come out the same way irrespective of who the judge is. And that's because, for the most part in America today, we are following similar methodologies. What are the methodologies? I talked about this earlier today. The elected representatives of the people in a democracy, the people that you elect to represent your moral will, they express your moral view through the acts that they promulgate in the legislature and that the governor or the president signs into law. And those laws may be tremendously stupid from time to time. There may be a law that we disagree with. Maybe a law that says that taxi cabs must be yellow. And as a graduate of Columbia, you may have a strong view that taxi cabs should all be light blue. But as a judge, you don't interfere with those kinds of decisions. That's the moral view of the elected representatives of the people as expressed through the laws that they passed. However, there are times when judges have to interpose themselves between the will of the people's elected representatives and the people who have bound us for all time, what's called fundamental or constitutional law. And in those times, we consider only the current law that was passed, and we juxtapose it against a constitutional provision, and we ask a simple question. Does that law violate a provision of the Constitution as that provision was understood at the time that it was passed? Most of the time, the answer will be no. And the law, good or bad, stupid or smart, will survive. Sometimes, when the law does violate the provision of the Constitution, then we declare it to be unconstitutional. But there's a whole, and that's mainly what people talk about when they disagree about judicial philosophy. But there's a whole range of decision-making that takes place, in particular in the district court, that has nothing to do with that kind of judicial orthodoxy. I'll give you an example. Judge Higginson mentioned fact-finding. That is a critical role of the district court judge in both civil and in criminal cases. The most obvious situation in which that presents itself is at criminal sentencing. We like to say that a federal judge should not consider whether the outcome will have this or that policy or political outcome, because you're not a politician and you're not promulgating laws. But there are rare instances in which a federal judge must consider the equities. And one of those scenarios is at sentencing. Because when you sentence a human being, you're sentencing the whole human being for all the things, good and bad, that he, and I say he because they're almost all he, has done, and for all the things that you try to predict they will do in the future. And you also, to some important degree, engage in a protective enterprise. To what extent does the victim's interest need to be vindicated? To what extent does the societal, community-based interest need to be vindicated? And in those critical questions, we do diverge, and we diverge a great deal. I'll give you one most obvious example, which came to the fore in recent Supreme Court confirmation hearings. The one kind of sentencing where federal district court judges disagree more than anything else, it's not nice to talk about, but it's child pornography cases. In child pornography cases, we're not talking about somebody who engaged in hands-on contact with a child. We're talking about people who view the material, either distribute it, receive it, store it on their computers, whatever. And the penalties are, let's say, they are increased and enhanced based on a number of factors dealing with how many videos, how many pictures, how young the children were, etc. There's a line at the very center, and on one side of the line, you have almost 50% of judges in the country, depending on the year, who see that crime as a crime of voyeurism, a crime of that's not violent, that's not hands-on, that's not, strictly speaking, dangerous. And these judges firmly believe that these sentencing guideline ranges for these types of offenses are just way too high, and mostly give what we call downward variances, much lower sentences for these types of offenses. And then there's another 50% of the population of the judges, I'm approximating here, who see this very much the other way. To be transparent, I put myself in that latter camp. And I view these cases as tremendously dangerous. And so do many of the people on this side of that spectrum, who see them, first of all, as gateway crimes to the more dangerous hands-on offenses, but who, putting aside the risk of recidivism that might happen with the person if released, who see this as the actual perpetuation of the victimization of the most voiceless members of our community, the defenseless, who are less fortunate than we have been and who desperately cry out to be protected, and whose victimization in those videos comes back to haunt them time and time again throughout their lives. Which is to say, it's one thing, and not to minimize it all, to be sexually violated at one discrete point in time. Horrible, we can all agree. And I was a human trafficking prosecutor when I was at the U.S. Attorney's Office. It's a whole other thing to have those moments memorialized for all time on video and circulated on the internet at the click of a button, so that you feel like you can never date again, like you can never meet friends again, like you maybe can't even go to college because the people in your dorm or the people bagging your groceries or serving your coffee might have seen you in the most vulnerable moment of your life. That's just one example of where federal judge decision-making diverges in drastic ways, depending to some degree on ideology, on perspective.
So I want to I want to talk about something you brought up earlier, which is whether people who are in the position that you two find yourselves should be speaking out, or to what degree or what the limits are on that. As we think about when judges speak and when judges don't speak, it seems to me there are a range of views. I think about Richard Posner, formerly on the Seventh Circuit, who would write books about the cases before him. He would criticize the Supreme Court, et cetera. Relatively recently, Judge Michael Ponser criticized Justice Alito for what he perceived to be ethical violations, and was then subsequently subject to a successful charge of judicial misconduct. Chief Justice Roberts recently spoke out about threats to judges and people saying that judges should be impeached based on their decisions, and he obviously thought that that was a time for him to use his role to speak about the judiciary. So there are determinations people have to make about what is in the lane of a judge or what isn't in the lane of a judge. And I'm wondering, how do you think about that in terms of your public persona and speaking to public audiences?
I'm interested to hear what Steve has to say, actually.
I'm going to try to be provocative here.
Go ahead.
Okay. Think of it 3 tiers, right? Our assigned job is to decide cases and controversies. Judge work is lonely work. That's all we're constitutionally entitled to do. Anything we do outside of that, you Americans do not owe us any deference at all. So that's the little world I've been most comfortable with. I can say adamantly, that's all you should ever hear judges doing. Over time, I've been now on the bench a little over 13 years. I've been pleased to accept and very agreeable to be involved in judicial governance. In other words, assisting the legal profession, whether it's on the Foreign Surveillance Court or in the rules committees or legal education even. The third tier is the one that I have great apprehension about, and that's where judges are slipping into the role of advocates or participating in any extrajudicial activity that is not furthering the nonpartisan unity of the judiciary. That should be for elected officials or for retired judges. Lately, we've seen a circuit judge, very respected, Michael Ludig, speaking out, a judge named Paul Cassell speaking out, Nancy Gertner, very different political backgrounds. I am so grateful they're speaking. Also, correctly, Professor Green points out, recently, our oath is to support and defend the Constitution. So I'm deeply, profoundly grateful when the Chief Justice, and he rarely speaks out, he spoke, Chief Judge Pryor from the 11th Circuit, a conservative, Chief Judge Sutton, another Chief Judge, conservative, spoke out just to remind Americans that we settle disputes in courts, and if you lose in a court, you don't defy the court, you don't try to impeach the judge, you appeal. That's all safe to hear. Here are 9 reasons that I think judges who step out of the lane are doing so wrongly. 9 quickly. Okay, you may want to take notes. Do you have any paper?
You're only
pen?
allowed to do 8.
Do you have any? You're going to need to write this down.
You
probably.
know it's all in here.
Okay, first of all, my mentor, right? We're all formed by our mentors. Byron White, about as heroic and large a person and influential, had he sought to, never participated outside of court. Extraordinarily private man. This is a man who was in World War II, Rhodes Scholar, #1 NFL football player. The minute he put the robe on, no extrajudicial involvement. Number 2, the text of the Constitution. All we're supposed to do is decide cases and controversies. We're not elected. Number 3, what did the framers fear? They said it in the Declaration. They feared that the king had subordinated judges. Judges were dependent on his will. My fear about the judiciary, we don't have a king, we have friendships, we have factions. I see dependencies emerging when judges align. They have some allegiance, some extrajudicial commitment. It could be a fantastic one. Prison reform, immigration reform, whatever their cause is, it becomes an allegiance. It becomes a servitude. It warps their viewpoint. Whether it's a friendship with a former law clerk, with a district judge. Friendships are sort of anathema to me in the world of judging. So the framers feared it. History proves outside engagements can be fatal. I know the Fifth Circuit. It had a majestic history during the Civil Rights era. Over 60 federal judges could not follow a 9-0 U.S. Supreme Court decision in Brown. They couldn't. Why? Because they had a servitude of their social commitment. Only two could, Skelly Wright and Frank Johnson. And when you look at them, they were isolates. They didn't have strong community attachments. So history is another one. The Article 3 job is anti-majoritarian, right? We are supposed to guarantee to those who are nonconformists, to those who are outcasts, to flag burners, we're supposed to guarantee the Bill of Rights to them. It's hard when you start affiliating with groups or majorities or get into the political game. So Article 3, sort of ideology. Our code of conduct, it forbids the appearance of impropriety. That's in other people's eyes. So if other people think that we have an allegiance, that means that we couldn't be fair to them. We have to respect that perspective of theirs. It's not whether we think we can be fair. Also, the code of conduct forbids ever bringing prestige of office to a commitment. And yet, anytime you see a federal judge out talking, you have to ask yourself, would they be given the podium if they didn't have the title they have? And my view is, if the answer to that is no, then they're utilizing prestige of office to say what they're talking about. I also think it's never a fair fight. There's a severe imbalance. When a federal judge talks to a lawyer or a law student or a professor, there's almost no way that the law student or the professor can rebuke back. It's not a two-way street. Rarely is it. Also, I think there's hypocrisy when they do it. In other words, except for maybe Roy, who may or may not want to tell you about his Senate confirmation hearing, most people, before they get the robe and life tenure, they will never talk about any topic, right? That's what Ruth Bader Ginsburg introduced. No premonitions, sorry, can't answer that, no intimations. So why is it the minute you get life tenure and you get a robe, you can go out and you can speak at law schools or you can join groups and be members, not just participants or speakers, but actual members of groups that look at intellect and politics differently. So I see a hypocrisy in that. Two last ones. Pragmatically, parties will lose in front of us. There will always be a party that loses. You never want that party to think, oh, the deck was stacked against me. That's an activist in robes. And they look at your past and there's something they said, well, they should be recused. You look around in headlines, there are motions to recuse, the government's filing, congressmen are filing. Anytime a judge gets out and does a public engagement, they draw a motion to recuse. Now, a judge can be cynical and say, oh, well, that's their problem that they want me recused. I don't agree with that. It's very hard for a litigant to file a motion to recuse. It takes a lot of courage because if they lose, they're stuck in front of that judge. I would never want a motion to recuse to be filed because of some outside commitment, however noble, of mine. Last comprehensive thing, it's a huge privilege for Americans to say you get to decide our cases and controversies. I think that privilege comes with severe restrictions. Judging should be lonely. You should have no attachments at all. Yes, I have a friend with Roy. I wouldn't be here but for that. But it's that assembly of reasons that led me to pretty much stay in the first tier, decide cases and controversies. Then I meet someone like Roy, and my perils of indifference point, and I realize, my gosh, this guy is spectacular for the democracy. Look at what he can achieve, and that creates dissonance. I still stand by my points, but over 3 years of friendship with him, if there were anyone I would want out there to be an activist, it would be Roy.
I want to get Roy's response to that, but I also want to put a finer point on what Judge Higginson mentioned, which is when he's talking about groups, one of the sort of obvious fora for judges to participate in public conversation, especially with the bar, is the Federalist Society and the American Constitution Society. Those are sort of right and left adjacent. They don't both necessarily claim to be, but everyone sort of associates them with particular ideology. Do you agree with Judge Higginson about engagement with these groups or on public events generally?
I don't agree with Judge Higginson, although he said it in the nicest possible way. And you see how he flattered me at the end.
Yes,
That's
I
the
did.
way to do it, you know? That's dignifying the opponent. I disagree with Judge Higginson about that. I am a member of the Federalist Society, and as are a significant percentage of our federal judiciary. The Federalist Society is not right-aligned. In fact, the Federalist Society, when I joined in law school and continues to be, I think, one of the great debating societies in our country, not just in the legal sphere, but on many aspects of intellectual life in the country. And I'm proud to say that the Federalist Society, I think, takes it upon itself very seriously to bring people of all perspectives to come and have discussions much like this one about the law, to push the envelope, even in areas where the audience might be in disagreement. I think the general point is, to go back to one of Steve's points, what we don't want is we don't want the litigants who come before you, either ex ante, before the hearing, or after the ruling has come out, to feel that they didn't get a fair shake because the thing was already cooked because of who the judge was. And I think that's a fair criticism. And I think each of us has an obligation to work extra hard in this overly politicized environment to make sure that when litigants come before us, they know they get a fair shake, to call balls and strikes and to call them evenly for one side or the other. And I'm proud to say that if you talk to the federal public defenders, for example, who come before me, even though I was a federal prosecutor, they would universally tell you that I'm tough, that I'm prepared, that I expect you to be prepared, and I can be tough on you if you're not, but you're going to get a fair shake. At the end of the day, you want to be in my courtroom because you're going to get every chance to prove your side of the case. And that's, I think, all we can ask of judges. And I think we can demand that of judges, irrespective of whether the judge, in his or her free time, decides to go to an intellectual debate about originalism or constitutionalism or globalism or whatever the issue is. But I have a more fundamental point to make about why I think it's important for judges to be outspoken. Not all judges, by the way. Some judges, they go out there and that might decrease the public's confidence in our democracy. I mean, for judges of good faith and ability to go out into the public and to explain what we do, why we do it, and why this system of laws that we've created, that we follow, is sacrosanct, why it's special, and why it bears to be defended. I was at Yale Law School yesterday, and a kid raised his hand at Yale Law School, and he said, isn't it fair to say that the judiciary just upholds all the criminal stuff that's going on with Congress and the presidency, and shouldn't we just throw in another towel on the whole thing and declare the whole experiment to be completely void and completely worthless? And I just fundamentally disagree with that. I disagree with it on the merits, but I disagree that he should not be disabused of that notion by someone like me who lives it every single day as part of my experience. And what I said to him in front of the whole school, I said to him, how much time have you spent in federal court? And he said 30 minutes. And I said, no time at all. So I said, I invite you to be an intern in my chambers next summer and to watch how my law clerks and I spend countless hours deciphering the messages of a person in prison for life who hand-wrote his pro se petition to me on the back of a napkin and sent it conventionally to my chambers, and how much time we spend digging into all the possible permutations of the legal arguments that he has made, and even sometimes the ones he hasn't quite made, in order to give him the fairest possible shake in his case. And at the end of the summer, if you're open-minded, a big if you're open-minded and you see how we treat the litigants on both sides, and you see how much care we put into every case, irrespective of partisanship or ideology, because all that is out the window, I think you'll be inspired by what a special jewel our judiciary is, not because of me, not necessarily because of my law clerks, but because of who we are and what role we play in protecting and establishing the democratic norms in this country. And I have to tell you this. I have been all around the country the last 2 years talking about the rule of law and the Constitution and our system, our democratic system. And I have found that what is desperately lacking in our democracy today is a firm understanding of what we do and why we do it. And in the end, that breeds contempt. And contempt leads to delegitimization of the judiciary. And delegitimization of the judiciary is a quick spiral to the end of a constitutional democracy. People don't understand why and how it is that sometimes the moral view that they as a community express through their elected representatives is cut down, is invalidated, is declared unlawful by unelected judges like us. Remember, none of you elected us. And there's only 500 or 600 of us for 350 million of you. We mostly don't represent you at all. We went to very fancy schools. We're mostly from a good socioeconomic background. In the end, we just don't represent your worldview. And so there's a natural tension there between a people that wants to conceive of itself as a democracy, on the one hand, and a people who in the newspapers see their democratic norms being struck down by unelected judges who, by the way, I'm here for life whether you like me or not very democratic. There's a natural tension there, and that tension breeds distrust. And I think it is doubly important now in an age where all of our opinions and decisions are broadcast not in full, but in 20 or 30 characters summarizing what we do. For those of us who can and who are willing to go out to the people and to explain what we do, how we do it, and why we perform our function, and why it is essential to the preservation of all the freedoms that you enjoy. And in the end, you may come across a decision of mine or of Steve's. You may say, I disagree with it. Altman got it wrong. By the way, my wife thinks I always do, so you wouldn't be alone. But I submit to you, if you've heard me talk about the role, if you've heard me talk about love of country, devotion to community, devotion to my neighbor, to my friends, whatever their political persuasions, you will be persuaded that I have approached it in good faith and with the right reasons. I may have made a mistake. I may have come to the wrong outcome, but not because I'm illegitimate. And that, I think, is an important function that federal judges can perform.
I want to pick up on this point about legitimation and maybe ask it from a flip perspective to what we just discussed, which is how the public talks about the judiciary and talks about judges. There was a recent incident at the Federalist Society Lawyers Convention at which a law professor, Steve Vladeck, appeared at the convention on a panel with Edith Jones of the Fifth Circuit, Judge Higginson's court, and Judge Jones criticized Professor Vladeck for what she perceived to be essentially politicizing the judiciary and calling them into disrepute, which she connected to death threats against colleagues. We all know that there have been other kinds of threats of violence against judges, and in fact, with Judge Salas in the District of New Jersey a number of years ago, an actual act of violence. Her son was murdered. There have been threats against Justice Kavanaugh as well. Is there a responsibility, you think, for people who are in positions of influence, who have a platform, to talk about the judiciary in a particular way, to not characterize it in a way that leads to people being too overly passionate about their decisions? Is there something special about judges in this sense, or the judiciary, that people with positions of power should take a certain kind of responsibility or stance towards in order to prevent the delegitimation or other kinds of threats to the judiciary?
Well, my view is Americans should criticize more, not less. We don't worry about judges. We have life tenure. We have an elite protective service, the U.S. Marshals, and we're blessed in America that it is very rare there's violence. It's deplorable. I'm glad prosecutors enforce obstruction of justice statutes here. 13 years, never even thought of a bribe. Virtually no threats. Colleagues have never, in any way, and I disagree with my colleagues often, have never disparaged dissent. You don't need to worry about federal judges. We have protection. We deserve it. Violence is never condoned. Those are crimes. They'll be prosecuted. What you need to worry about is the opposite. You need to worry about judges with their power getting involved extrajudicially and chilling critics, especially students, especially faculty, although they have life tenure too. And it is easy, for judges to do that. We are government officials. It is the government. And so do not ever be cowed from criticizing opinions, right? Our opinions, who are wielding power, and it often is final, as one legal historian called it, it is jurispathic. Many disputes, they're debatable, perfectly debatable points. It's just our job to decide one. Well, if you lose, you should be critical. That's Americans being pugnacious and pluralistic. The other bigger danger is the opposite of criticism, which is back to a point I made before, over-adulation, over-veneration. When judges go out and participate in groups, they get extraordinary adulation in this country. That's the danger that I see. It is not that scholars and students are somehow critics that are destabilizing the judiciary. I feel very strongly about that, as you can see. We're very protected. Did you disagree with
No,
with
I
that?
actually, I unfortunately agree. Again, I think there's this natural tension in a democracy between who we conceive of ourselves as a democracy and what in practice happens sometimes, where unelected judges prevent the will of the people from being enacted into positive law. And that, I think, can be frustrating. It can be disconcerting. And I think it's natural and healthy in a democracy for people to criticize judges when they don't like the way they have come out one way or the other. I also, by the way, I assume this is what Steve was talking about, I also think it's fine for politicians, who, after all, are the elected representatives of the people, to voice those concerns. Those politicians are going to have a bigger microphone, a more amplified message, and to the extent that we're concerned that everyday people won't have the opportunity to criticize federal judges, I think it's appropriate and healthy in a democracy for their elected representatives to criticize us. Look, we are blessed. We have the honor of devoting our entire lives to the greatest constitutional project that has ever been conceived. Take a little bit of criticism here and to be humble and recognize that I could have been wrong and that my decision may be deserving of some level of opprobrium. It's perfectly appropriate with me, and I think it's tremendously healthy in a democratic society. I should say, there's a line, and what we have seen, and Jamal mentioned it, we have seen physical violence against judges, and we have seen threats of physical violence against judges, and of course, that can't be condoned.
In the last few minutes we have together, I want to ask you each a couple of questions that maybe point in slightly different directions, or maybe in some sense opposite directions. One is, in this moment of great anxiety for the nation, there's certainly lots of anxiety on campus, among other places. What is it that keeps you up at night? What is it that you really worry about when you think about our democracy, when you think about the future of our constitutional democracy? And then on the flip side of that, maybe it'd be good to say this second. What are you optimistic about? There's a lot of doom scrolling that happens these days, but what do you look at and say, you know, maybe we're going to be all right? I'll
start with the pessimistic thing. I have been on 60 campuses over the course of the last year and a half. And I'm not that old. I was here not that long ago, and it was a pretty progressive place. But I just went to Yale Law School and sent a text to my group from Yale Law School that I was going to be on campus, and noticed that about half of the group were liberals and about half were conservatives. And you know what? It had never crossed my mind before. Because you know what we were first and foremost? We were just friends. We were just participants in a shared mission of intellectual curiosity, of learning, and ultimately, deep down, love of country. And what I have seen on campuses all across this country, and sadly here at the campus that I love most of all, is an inability to find common ground, as Steve mentioned it, an inability to share with one another, an inability to see the humanity in the other side of the argument, to even be humble and open to the possibility that your view, factually, legally, morally, maybe isn't right. You know, in the law, what's blessed about the law is that everyone gets a lawyer, which means that everyone has their side of the story. And it's the job of the judge to sit in judgment and listen to all sides and decide which one is true and which one is not. You can't do that if you're closed-minded. You can't be a lawyer if you're closed-minded. And I submit to you, can't be a member of a free and democratic society if you're not willing to engage in open and honest dialogue with other people that at the same time is dignified and respectful. And so I'm concerned about how we talk to each other and the lack of respect that we have for one another's views, and principally for the lack of humility we have for the possibility that our own view might not be the correct one. But here's what I'm optimistic about. I do something that Steve doesn't get to do. I bring jurors every single trial, members of our community, not lawyers, not fancy law professors, not judges in robes, everyday people from the community who come in and sit in judgment of their fellow man in our courtrooms. And they do it in every county and district across this country every single day. And I tell them when I select the jurors, I say, when I call out your names, the lucky souls who are selected, I'm going to look into your faces and I'm going to see one emotion imprinted there. And that is horror, right? Why did this crazy judge select me to be on this jury? I'd rather be in my cubicle sending and receiving emails like I do every single day. But you know what? At the end of the trial, I go back to the jury room and I shake every juror's hand. And I give them a certificate that I've filled out for each and every one of them, thanking them for their service to their community. And I have to tell you, after every single trial, and I've tried about 50 now in 6 years, I look into their faces and I see a totally different emotion imprinted there, and that is gratitude. You know why? Because these are people from all walks of life. They're black and Hispanic and white. They're Jewish and Muslim and Christian and atheist. They're rich and poor and retired and everything in between. And they watch our television and they read our newspapers and they become convinced that this experiment, this beautiful experiment that one, unless you came in the Mayflower or something, 1 or 2 generations ago, all of our families fled whatever we were leaving behind to come to. And that beautiful experiment is dying. That's what they see on television. And then they come into the jury room and into the courtroom and they listen with dignity and respect when every other juror speaks. Then they stand up to speak and they're treated with dignity and respect in turn. And then, despite all the differences and prejudices they came in with, they come out into the courtroom and they speak with one voice and render a just verdict, effectuating justice in their communities. They get to see firsthand that the country they loved, the country their parents or grandparents fled to, it's not dead or dying. It is thriving and flourishing. Why? Because the country is just every single one of you. It's just a collection of individuals who have the power, who have it within their grasp to bring us to achieve our greatest ideals. And that system, where I get to see jurors every day, people from the community, and where the people from the community get to come in and see public justice every single day, the kind of justice my family didn't get to see in Venezuela, the kind of justice Judge Lagoa's family didn't get to see in Cuba, and that many of our jurors didn't get to see in Haiti and other places. That gives me optimism about the future. And I'll just say one last thing. In the last trial that I had, a 3-week trial, an imposition, I accept. I went to the jury room and I shook all their hands. And at the end, the last juror was a lady named Miss Benjamin, a Haitian woman who walked with a stroller, with a cane. She had a great deal of difficulty walking and getting up. And I went to shake her hand. She said, "I won't shake your hand." And I said, "Oh, I must have said the wrong thing." And she stood up. I said, "Miss Benjamin, don't stand." She said, "I have to stand." She said, "Because I have to hug you." And then she hugged me and she started to cry in front of all the jurors and everyone on my staff. And she said, "I fled a country, Haiti, where the government would never have accepted that a little old lady like me gets to decide whether the government did right or did wrong by a member of our community." And she said, "I will take this experience with me until the day that I die, and I will tell everyone I meet about what a special judicial system we have." She is an apostle of our democracy, and that makes me optimistic about the future.
Can I take your closing time?
Absolutely.
Okay. Give me more than 1 minute, please.
Cut him off
Okay.
now.
What do I worry about? It's back to the people that taught me in college. I just gave a lecture about the Nuremberg trial, especially the justice trial. And what I see there is it wasn't indifference that collapsed the legal profession. It was affiliation and ambition. So what do I worry about? Government speech, especially mocking or cruel government speech, especially aimed at vulnerable people. If you want to go listen to any one thing, Toni Morrison's Nobel lecture speech speaks directly to that issue. Third, I worry about government attacks on non-governmental institutions, especially universities, not just because they're supposed to be the academies of free study, but especially because they're meant to have nuisance value. The nuisance value of a university is its essence. I worry when students are attacked, even misguided and exuberant students. My read of history, students have never demised democracy. Students have always been our conscience. I worry when lawyers are attacked who have to defend unpopular people, when courts are attacked who have to defend against anti-majoritarian impulses, and especially when there's a climate of fear to be a public servant in this country. I worry when the press is attacked because the press is typically the one that exposes judicial corruption, that exposes judicial engagement. Those are my worries. Those are very substantial worries. Where's my optimism? Youth. It's my children. It's my law clerks. It's looking at you. There is no cowardice in American youth. We are giving youth a lot of problems. That's where my optimism comes from. I also think it's a great time to be a lawyer. I mean, look at Thurgood Marshall as a lawyer for blacks. Ruth Bader Ginsburg for women as a lawyer. Abe Fortas for criminal defendants. They faced bleaker times. Mary Bonato for gays. So it's a great time to be a lawyer because a lot of people face adversity. And I guess cynically, do you know the play A Man for All Seasons? Some of you? Robert Bolt. At the very end, Roper says, well, basically I'm simplifying it, but he says to Sir Thomas More, we should chop every tree down to get the devil. You know this scene? It's called the Devil's Speech. Sir Thomas More looks at him and says, so when you've chopped all the trees, the laws, down to get the devil, and the devil turns on you, where will you hide? Now, why am I optimistic? Because that applies to everyone. Everyone in our country, highest, and lowest, has needed the protection of the laws. So cynically, in the end, even the most warring people in this country will cherish the laws and the courts that have protected them when they've felt persecuted.
As they say, the case is submitted. Thank you for this wonderful and civil conversation.
Thank you.
Thank you for joining us for today's event. Please use the doors at the rear of the rotunda to exit.